I'm joined here this evening by my colleague David Martin over here, and of course my colleague Jessica Friedman here at the front. As far as our panel this evening, we have leading the panel Ted Savity, Principal of Savity & Associates. Savity & Associates is another sponsor of NYTECH Alliance, so we're very happy to have Ted with us this evening, as well as my colleagues, I mentioned Jessica Friedman. With that, Ted, I will leave it to you guys to introduce yourselves and take it away.
Okay. Welcome, everybody. Can you hear? Are these microphones on?
Yes.
There. Good. Let me start with the first slide. So tonight we're doing Intellectual Property Bootcamp, and the way we'll divide things up, it's a big topic. We're going to cram it into a short period of time. Usually it takes people years to learn these things in detail, but we'll get you guys up and running in a few minutes. And we're going to go over, we're going to focus on, I'm going to go to the podium, it's sort of easier I think than me staring at the screen backwards. We're going to focus on things that are relevant to typical early stage tech startups. And then I guess we'll open Q&A at the end. Jessica, is that how we should do it? Just go through, roll through it. The most important thing to learn from tonight, the goal for tonight, is not to become an expert at IP law. The most important thing to learn from tonight's presentation is when do you call your intellectual property attorney so that you don't let the cow out of the barn before you try and close the gate. Because this happens a lot, which is why I'm very happy to give these sorts of talks, because too often I have people coming to the office or call me on the phone, they want to take care of something, and I find out, oh, too bad, you missed that deadline. So this particular issue is often overlooked in the race to the market when a startup begins, especially after it's received its Series A financing. So we're going to be talking about 4 legal regimes, and you've heard these words before: copyrights, patents, trade secrets, and trademarks. Now, you have to keep in mind that these regimes often overlap and interact with each other. And the other thing we're going to get into is essentially US law, but these intellectual property regimes have international counterparts, especially in the patent, copyright, and trademark area. So why do we bother with IP if you're starting a company with its new fast-moving technology? Well, one reason why I have clients that are very interested in getting intellectual property established over their innovations is to ameliorate the risk of people reverse engineering their technology. The other is to ameliorate the risk of employees who get poached by their competitors. And it also establishes a set of assets for a technology company that otherwise would merely have a few desks and a few laptops. This provides a means sometimes for secured financing. And most importantly, intellectual property protection provides a way for a company to block its competitors from freeloading off of the business that you worked so hard to develop and proselytize into the market. So we'll begin with copyrights. And Jessica, feel free to interject anytime. I mean, I feel by staring here I'll be able to better work that than if I was there looking backwards like this. So copyrights protect, and I'm really paraphrasing here, they protect any kind of authorship that's fixed in a tangible medium from unauthorized reproduction, transmission, or derivation. And that means even things that are substantially similar, so long as it's something that can't be demonstrated to be independent authorship. And so in law we call that access. So things that can be subject to copyright protection are certain kinds of text, books obviously, graphics, audio, music, audiovisual, movies, 3D objects. So if you have something you're making on a 3D printer, that could potentially be subject to a copyright. And what do we mean by fixed? That means things like if you store the data representing a user interface, which can be copyrighted, into video memory, that's now fixed. Making the JPEG of an image, source and object code of a computer program is fixed in memory, and that's copyrightable. AVI files, MP3 files stored in memory, or on disk, web pages, or even jewelry can have copyright protection. But copyright does not protect the underlying idea. We call that the idea-expression dichotomy in the law, which is the expression itself can be protected, but the idea behind it cannot. So that's where the other regimes come into play with the technology, because for people in the software realm, it means you may write a piece of code that expresses a particular process that's innovative. The code is protected from being copied and distributed without your permission. But if somebody reads the code and goes off and writes their own program, that may not be copyright infringement, unless the program they come up with, the actual code itself, is substantially similar to the one that they read. So that means that the processes underlying your software may not actually be protected by the copyright. What's being protected is people freeloading by just grabbing the code and not having to come up with their own code development in parallel. I don't know if people get that distinction, but it's important. I don't know if you have any comments on this.
Well, I mean, I sometimes give examples of the idea-expression dichotomy, so I'll pick one that's very dear to the heart of all lawyers, which is billing software. Okay, there are many, the idea is to bill for your time, keep track of your clients, keep track of the money that comes in and all that, but there are many, many different programs that express that general idea. So that's just one example. I mean, if you want an example that has nothing to do with technology, you know, think of the story plot. You know, girl from one side of the tracks meets boy from the other side of the tracks. They fall in love, and tragedy ensues. So you've got, you know, Romeo and Juliet, and you've got West Side Story. Same idea, completely different expression.
And actually, it raises an interesting point in copyright. There's certain things, going back to the technology realm, that she raised a concept we refer to as scenes à faire, or merger. That's where the expression and the idea start to get merged together, in which case there's no copyright protection. Excuse me, in the software realm, that comes up if there's only one particular way to express an API. Let's give an example. So you're going to target, or you have an API, and you want to own that API somehow. If the API is a particular process for interfacing into your system, and there's only one way to express the particular interaction, because it's a tight piece of code, 30 lines of machine code, it may be viewed as not being subject to copyright at all, because that would mean that the copyright protection would prevent people from utilizing the process. So that's the way the law works on that. So what is your competitor, let's say, prohibited from doing? Making copies of your software, transmitting the software from one server to another, and then even taking your software and modifying it and making a new piece of software out of it. That would be prohibited as well. So, generally speaking, copyrights in the software realm, I believe, are still valuable, because even though the underlying process and idea may not be protected by copyright, what is being protected is all the man hours and women hours that went into debugging 2 million lines of code and compiling it and working with software engineering so that the runtime footprint is small and it's stable and works on a broad range of target platforms. All of that work really goes into not necessarily developing the process, but debugging the expression in the code such that when it's compiled and executed on a variety of platforms, it doesn't blow up, right? That's the hard work. So, copyright does protect that kind of work, and in some sense, that's where a lot of the value is. So, that said, this is what a copyright registration looks like. We do recommend people get registrations, because if you already hold the registration, when a copyright infringement starts occurring, certain advantages in court to having that. It's not fatal to your claim, it gets into questions of damages and things like that. So this is an example of one of our clients. Title of the work is the Shopkeep Register for the iPad. It was completed in 2011, and the interface was, the author of the interface was Ronald Reeser. Audiovisual material, and somewhere over here it's going to say it was there's a work for hire, made for hire, because they're employees, and and who owns it. So this is now has a registration number. So that's interesting, because in this case, this is being filed. We took a user interface and filed copyright registrations on the appearance of the user interface, because leaving aside code for a second, the actual appearance of the user interface is copyrightable as well, because it's an audiovisual, can be viewed as an audiovisual work. Now, it's also possible, and we did this with this particular client, we filed copyright registration on the code that actually presents this interface. So there are two different copyrights that we have. So even if you wrote your own code, but knocked off the appearance of the user interface, that could be copyright infringement. You follow what I'm saying? So that's how we play around with this stuff in terms of establishing barriers to entry to competitors in the software industry. Let's talk about copyright pitfalls, because that's what we're here for.
Wait, can you back up 1 second? To the other slide? The other slide. Yeah. So just a couple of comments on this. Copyright protects, it has to be original authorship. And original doesn't mean like a patent, which I think is like novel and completely unique and all that. So original in copyright means it's got to be independently created, you didn't copy it, and it has a minimal degree of creativity. And that's really pretty minimal. I don't even know exactly what the threshold would be in software. But that's something to keep in mind. And on the question of substantial similarity, I mean, here's the thing. If you think that someone's copied your code, chances are you did not see the person actually sitting there looking at your code and literally copying it, but you have to be able to prove two things: that the infringer had access to your code, and that the code that person created is substantially similar in copyrightable expression to your code. And there's a million things to unpack there that we can't possibly do in a little panel where we're covering 19 topics. But those are just a few things to mention. Plus, you mentioned on that slide, initial ownership is in the author, and in copyright, and in copyright, the author is the person who creates and who owns a work. So generally speaking, the person who creates something, the developer, in your case, we're talking about technology, will own the code unless one of two things happens. One, Ted mentioned work for hire, and I mean, how many of you have heard the term work for hire? I'm sure you have. Okay, so it means a couple of different things, just to throw this out here. If you work for a company, you're an employee, and you create something in the scope of your employment. So you're hired to write programs that enable something to happen. I don't know, go back to my example. You're hired to create billing programs, and you create one. In copyright terms, that would be within the scope of your employment, and that would belong to your employer, even if you never signed an employment agreement. So that's one kind, done by an employee in the scope of their employment. The other kind, let's say that you're an independent contractor and you're doing a project for a company, you're not an employee. In that case, you're still going to own that code unless there's a written document in which you assign your code to the company. And if you are a company hiring freelancers, that's why it's really, really important to make sure you've got the right paperwork, because otherwise Ted will talk about the pitfalls.
Yeah, no, that's what I'm pointing
that
out.
was
That's
one
the
thing.
first pitfall we're about to get into.
Okay, and one more thing, because it was on the first slide, I mean, I don't want to screw up the flow here. So about a registration. Yeah, you don't need a registration, and yet you can't get into court without one. You cannot sue for copyright infringement without a registration. And what Ted said about the advantages, one of the big advantages is if you have your registration before the infringement happens, in a couple of other circumstances too, but basically, then you go after the infringer. Let's say that you can't prove that the infringement cost you any money. Then you can still ask the court to award you damages based, something called statutory damages. The court can award you money even if you can't prove you lost any, within a certain range. But without a registration before the infringement, you don't have that option. So it's really a good idea to register, even though you have copyright rights without registration.
So that's why, well, we didn't put it in here as a pitfall, but it is highly recommended to be filing copyrights on aspects of your software as the products roll out and the revisions come in order to have that litigation advantage. But I want to reiterate these pitfalls that Jessica was getting to. One of the big ones we see all the time is this first one, company hires a coder as a contractor. They find somebody on the internet through Craigslist who says, yeah, I'll write that website app for you. And you get around to a particular financing event a year later, person's gone, right? And you find out, uh-oh, I thought we sent them an assignment, but you see the email going out, and it's a blank form, or it came back as a blank form with no actual signature on it. Big issue. Generally what I recommend, you hire somebody as a coder, as a contractor, you don't make the final payment until they get you an assignment back. You'll find that really works wonders to get a signature on a piece of paper. You need a real signature on a real assignment, and it has to have the right language in it. Again, this is why you want to talk to an IP lawyer. This isn't something you do at home. The other pitfall, we sort of got into it goes into the original authorship comment that Jessica made. The coder finds code on the internet somewhere and grabs it and integrates it into your website or your other application without a license. Now, that itself is a problem because now you don't really own all of your code. It's not licensed. It has copyright infringement built into it. But then you get sometimes, the other examples, it is licensed, but it's under this open source type of open source license called copyleft, that your license requires you to disclose all the source code of the program into which that component is integrated. So all of a sudden, if you were going to be selling the software, you got a problem. And you don't know that's in there. And that's a big issue. And what happens at a financing is they make you in the financing, make reps and warranties that none of your code has these kinds of licenses in it, and you make the representation and warranty, and then you find out a year later it does. Well, now you got a problem because you made that representation and warranty in order to close your financing. The third thing goes into some of these social media sites for distributing or sharing content. Your users upload unlicensed music or video to your website that you automatically distribute, but there are other aspects of the operation of your service that don't comply with the safe harbor rules under the Copyright Act, which means now you are the unauthorized distributor of somebody else's copyrighted works. Okay, and that's the whole big lawsuits that went on with YouTube and some other companies over what constitutes complying with what they call the Digital Millennium Copyright Act safe harbor rules. And I don't want to get too deep into this because we could spend an hour just talking about that. But if you have a comment you want to make over that,
just a couple of things. If you operate a social media site and you get a notice from someone that says, hey, your song, your movie is on my site, you have to do, that's called notice and takedown. Read the damn thing, find it on the site. If the letter complies with the law, I mean, they have to tell you, show that they own that thing, they have to tell you what it is so you can find it. If all that thing's happened, yes, take the thing down and go to the person who sent it to you, if you can identify them, and say, hey, I have to take this down. If you want to prove to me that you've got a right to put it up, that's fine. But basically, don't ignore those letters. Yeah. That's when you really get killed.
But there's another thing besides that. That safe harbor aspect, that's the safe harbor. There's another thing. That ability to comply with notice and takedown doesn't work. It's not available if you're acting in some sense in an editorial capacity, deciding what content gets uploaded. And now there's a new lawsuit, which is really very interesting, where a company has one of these music sharing or content sharing websites where they have the users decide by voting or some mechanism like that, a certain subset of their users decide which sort of gossipy news clips are of interest to the rest of the user community. So now the question is, are those users acting as an agent for the website, and therefore the website through its agents is in an editorial capacity selecting what content will be displayed, in which case that whole safe harbor thing Jessica's talking about doesn't exist as a defense, and they're liable for copyright infringement directly. So this is a place where, again, talk to somebody as you're putting your business plan together who knows how to deal with this. Another pitfall that I've seen, and these are all things that I've seen, by the way, all the pitfall stuff in the slides, these are things I've actually worked on. You license your software in a breezily written document that lets your competitor click through to get the license and then use your code. These people put together this quick and dirty click-through software license on their website, so the competitor clicked through, and because of the way it was, the language of use was described, they downloaded the object code and they decompiled it and used it. And when we complained, they pulled us out and said, we have a license. What they did was they kept screenshots of them clicking through the license. They knew what they were doing when they did it. This is something they knew what they were doing. They looked at the agreement and said, these guys screwed up. And so that was a pitfall. So again, these are things you want to avoid. How do you, I know it sounds like I'm selling my services, but yes, you have a question?
So when you do copyright, do you have to disclose the entire source code?
Oh, that's a very good question. No, you don't. When we register code, what we do is there's a thing they call, I forget the phrase, what is it, Melissa, rule of, you give them 10 pages of code you're willing to disclose, you're allowed to redact some of it, and then you can use that, you can include that with a zip file if you want, that doesn't go, isn't available, or is encrypted. There are a variety of mechanisms. They've addressed this, so that should not be, it's a very, very good question. When you're registering code, you can register the executable, and that counts, and we've done that many times. We've even simply filed a registration on the install package. We just took the install package and sent it to the Copyright Office, and they accepted that as a what they call a deposit. So there are a variety of ways around that issue in terms of keeping your code secret, even though you're filing a copyright registration on it. So that's a very good question. Thank you for that question. That's a very good question. Did everybody understand that? Yes.
So follow-on question to
Yeah.
that. So if you're copywriting interfaces,
Yes.
user interfaces, would you still have to submit code, or could you just take
No,
a
you could do it with a
picture
screen.
of
This one
screenshot?
was sent in as a screenshot. It looks like this. Bing! So that was it. But we also recommend doing both. We do both the code when it's appropriate, and we also do the user interface screens as well. We try to get all the angle on that. We're going to talk later about design patents. We've also obtained design patents over user interfaces. Yes, sir.
Just curious, if what you're copywriting is a product that includes code and graphics and other things, is the notion that there's one copyright for the entire thing, or are there individual?
That's a very good question. If it's the code that will turn into the various things that are being displayed, like it's right, then it's all can be viewed as all in one. It also can be viewed as a compilation. Usually we don't file the software as a compilation, but what I do is I look at specific aspects that are noteworthy, and that's where we talk about the user interface. If there's a specific look to your user interface, we will separately file on that from the actual code itself. So it depends on the situation. I don't know, Jessica, you have comments on?
No, it's just complicated. I mean, there are 6 different forms that one can use to file for copyright. One is text, which includes software code. Then there's graphics, then there's other, so first of all, you have to figure out, in other words, almost the reverse, what will fit into which category. And if you can't fit everything into one category, you will have to file more than one application.
We generally recommend more than one. If you put $1 million of development costs into a piece of code that has a beautiful user interface and an amazing inner loop engine doing some amazing whatever it is, right? We generally will recommend by the end of that development there's going to be 2 or 3 copyright registrations over your user interface. There's going to be at least 1 copyright registration over the whole block of code, and there's probably going to be 1 or 2 patent applications pending on the underlying process, which we get to next. So we'll turn now to patents. I know I'm saying we didn't do Q&A at the end, but I guess this is a nice place to do it. We'll take 2 questions on copyrights. Any more on copyrights? And we'll skip right to patents. Yes, sir.
What about when you're doing new releases, like, do you have to refile copyright at the time?
Well, that's a very good question. There are a number of views on this. A lot of clients file on the 1.0, they file their copyright registration. Then the 1.2, 1.3, 1.4, 1.45, they don't. Then when they get around to the 2.0, they might file on it. It depends on how much the code is different, and if the code is changed extensively, I generally recommend filing another registration. I don't know what your recommendation on these are.
It's simply this. What are you going to use the registration for? you're going to use the registration to go after an infringer. And for that, the code that's registered, if you want to show that this guy's code is substantially similar to your registered code, then it had better be substantially similar to your registered code. So if you registered 1.0 and now you're up to 2.0 and it's very, very different, and somebody's infringed, somebody is making, has a product with code that's very similar to your 2.0, but not your 1.0 that you registered, you're going to have a very hard time making out a case of copyright infringement in federal court. I mean, look, you always hope you're never going to get to that. Litigation's expensive. It's all that. I'm not saying that's where you want to be thinking, but that's the purpose of the registration, to protect your rights and enforce them in litigation if you have to. And that's why it's important, like Ted said, if the code is 1.0, 1.1, 1.2, I mean, it depends. Maybe 1.5 is really, really different. You have to have a sense of the importance of doing that, and have a sense of how much the code has changed. I think that's a fair.
That's the really point. That really was what it boils down to. I mean, if you're fixing bugs, you know, gee, there was somebody put a backslash comma, it's supposed to be comma backslash. I don't know if it's going to make a great deal of difference, you know. But if now all of a sudden you rip out an entire parsing engine and you put a whole new parser in for an entirely new slew of input formats or whatever it is you're doing. You know, maybe that's more extensive. So that I think it has to do with how much effort went in to go from version 1 to version 2. Go ahead.
And how costly is it to file?
Oh, it's not very costly. And I can't, it's hard to give quotes because I don't know what everybody's problem is. But generally, it's very quick, not too expensive. They don't really examine the copyright to see is it really copyrighted. They just look to see whether the particular deposit you're making of what the work is meets their requirements as bureaucrats, they rubber stamp it, and there it is. So it's not as extensive as what we're about to get into in patents. So.
I mean, it's like, there are 3 categories basically, and there's $35, $55, and if you go in hard copy, they really don't want you to file in hard copy anymore, $85. And then there's certain ways to register groups of work. I mean, that's a whole separate topic. But the copyright, if you go to copyright.gov, they have a lot of really good, their circulars are actually pretty good. And you can find the information, they'll talk about fees, and they'll talk about a lot of that. I'm not saying that's going to qualify you to file your own copyright application, but it will certainly give you that information.
I don't recommend, especially in software, filing your own copyright
I don't recommend it either.
because it's very easy to have a copyright registration that doesn't stand up for purely bureaucratic reasons, and you'll be kicking yourself if you ever have to enforce one. But let's now turn to patents, because I know this is going to be its own ongoing. So what does a patent do? Well, it protects any new and useful process, machine, manufacture, composition of matter as defined by the patent claims that you get from unauthorized use, manufacture, sale, importation on or after the patent issue date. Now the important thing here is you notice that independent invention doesn't count. So if you get your patent and a year after it issues, somebody not knowing about your patent decides they're going to do the same thing, they may be infringing your patent. They can't say, oh no, I worked on this by myself. It's too bad, so sad, but you're there first. However, to get your patent, you have to apply to the U.S. Patent and Trademark Office and submit patent claims that get examined by the examiner. The examiner looks at your patent, reviews it, runs what they call a prior art search to determine whether or not it really is a new invention. And I'm really paraphrasing the law here. And it takes 2 to 3 years to do this. And then the patent office, if they like your claims, you get an allowance. Normally, if your claims are appropriately broad, where you're really trying to get what you really deserve, the examiner will issue a rejection. So then we respond to rejection with amendments and argument. And this goes back and forth a bit. And then finally, they issue a notice of allowance, and your patent issues. Now, the key thing is the claims must be novel, non-obvious. That means it has to truly be a new invention. It hasn't been invented before, and non-obvious, meaning it isn't an obvious combination of what's already out there. Over the prior art, meaning whatever things are out there, articles, patents, machines, products, software, that are already available at the time of filing. So the big pitfall here that we do run into is your own work becomes prior art in 1 year. Okay, everybody heard that clearly? So, you invent a new signal processing methodology to perfectly interpret speech in multiple languages and turn it into text with 100% accuracy, okay? And you have this entirely new signal processing algorithm, and you develop the software for it, you release the product, 2 years out, after product release, you realize this thing's worth a lot of money, and now it's getting knocked off by, say, Nuance, and you want to go back and you call your patent attorney, uh-oh, it's more than 1 year since you commercialized it and offered it for sale. You can't get a patent over it. Everybody get that? Any questions about that? Okay, so this is the one that's the real name patent pitfall. Okay? So waiting too long to file your patent application, it's a mistake. Plus, the new patent statute that came out in 2013 moved the United States from a regime where the first inventor in competing inventors who both came up with a similar idea around the same time, the first inventor to invent wins the race? It's the first inventor to file, okay? So you and your competitors, and this happens more often than you realize, you and your competitors are all having very similar ideas. I hate to tell you, it's not, the technology world isn't, it's a lot like the music idea, you know, you ever listen to rap records? How different are rap records from each other? They aren't that different, right? Come on, let's face it. Now, how many times have you heard the impeach the president loop in a rap record? So the point is that the amount of innovation, it kind of goes between competitors like this, right? Right? So what happens is your competitor may leapfrog you or want to leapfrog you. They look at your product line and go, well, what if they did it like this? And they file a patent on it. They got there first, even though you were working on that particular new version of what your system was going to do. So that means it really is these days, you know, you have to think about what we call filing first and often, which is we file what they call provisional applications, we'll talk about that in a second, on a regular basis, and then by the time the first provisional expires, we wrap it all up into a utility, and that's how we try and maintain filing dates at the patent office. That's for the clients I work with in the software area typically that are very active in building out their IP portfolio. This is what a patent looks like. This is one that we got for Workshare, British company. So this is a method for securing documents on a remote shared storage resource, and it has to do with using this complicated thing involving a series of cascading encryption keys. And so here's the inventor, the assignee is Workshare. Here's the application number, it was filed in 2012. It claimed priority to a provisional all the way back in 2011. And this is the prior art that was cited in the examination, and then begins the whole thing. And I should have put in the claims to show you. So there's the patent number up there, and there's the issue date in 2015. So that's what a patent looks like. So what are the patent pitfalls? Now, before we get to that, I just want to talk about what the patent covers again. I want to reiterate that. It can cover the things that copyright doesn't. So copyright doesn't cover the idea of a particular process. Your algorithm, the idea of your algorithm that does the special signal processing of audio to do perfect conversions of speech to text, that can't be copyrighted. The code can, but the idea of how to do it, maybe it's because, I don't know, you don't use any of the frequencies between 100 hertz and 500 hertz. Whatever the magic is, that's an idea. You can't copyright that. But you can get a patent over that process. A method of converting speech, audio in the form of speech signals to text by using an equalizing algorithm to remove the frequencies between 500 hertz and 1,000 hertz, and on. That can be patented now. Question?
Two questions. So on the point of 1 year for your own work becoming prior art, especially in software, if you've created an algorithm, it's not going to stay static for 1 year. You're going to keep improvising and doing frequent releases. So even after 1 year, your original work is not going to look like what it was.
Well, that's a very good point. And what we've run into is the more core processes don't change that much, and because the claiming isn't around the most narrow, specific steps in the software. It's the overall general steps. So while you might have 100 steps required to, let's say, remove the audio signal between 100 and 500 hertz, maybe that all this complicated stuff, in the patent claim it just may mean attenuating using a predetermined function, the frequencies between 100 and 1,000 hertz, right? And so that gets to how we do the claim drafting, so it's broad enough to cover some of the variations. On the other hand, if you really are changing the underlying processes, a lot of times what we have is we have the initial file that's fairly broad, based general idea of how we're going to do it. And we know that might be a little shaky because there's an issue called enablement we won't get into. Then what happens is, as you refine the invention, you run back to the patent attorney, we file another application that has a lot more detail in it. Then you might, a few months later, file a third one, and then several months out, we file the official utility application that incorporates all these earlier ones, and when you do it right, you get the benefit of that first filing date.
So the second question is,
Yeah.
follow on to that when you're filing so many times, and the moment you file,
Right.
your idea, your thought, your concept becomes public, and that just, I don't know how much.
Well, let's back that up.
protects
It doesn't, not upon filing, it's 18 months from the priority date. So let's assume you file a provisional application on January 1st of 2018. Then that will turn in, you'll have to file the utility application by January 1st, 2019, and that application, in theory, won't publish until June 1st, 2019. So you do get a benefit of that. Here's another thing. If you're only filing in the United States, you can check a box on a form where you promise the patent office you're not going to take this application international, and they'll keep it secret until the patent issues. So you have that, you can make these strategic choices, but I don't want to get into all that fantastic detail. Call your local patent attorney on that stuff, but those are all very good questions. So let's talk about other typical pitfalls we see early stage companies doing early in the gestation of the company. You offer your patentable software or website innovation for commercial use, but you wait over a year to try and file a patent application on the underlying process. Does everybody get that mistake? Okay, so if you think you have, and the other thing is, don't take your engineer's word for it when they say, this thing is, this is so easy what we did. I run into that a lot. Now, I used to be an engineer, okay, so if you don't believe me, you can go look on our website, the stuff that I've done in the past. What I've seen is what engineers consider, they consider anything they've done easy once they figured it out. That's not the measure of what's obvious. What's obvious is before you figured it out, was it obvious to come up with a solution, okay? I'm sure when they asked Albert Einstein about general relativity, well, that was easy, but it took him, what, 30 years to write it. So you do want to look into that if you have some kind of engine that you've invented doing some kind of a new process that nobody else does. You wait less than a year to file, but your competitor releases a competitive product with the same thing the day before you file. So now, that's not you as prior art having a year grace period, that's your competitor creating prior art the day before you file. Ouch. You hire, I've seen this a lot, and we have a little business out of this. You hire patents.com or one of these other websites to file your provisional patent for $150, and then you discover a year later that the disclosure that you filed is inadequate by law to support the patent claims you want, and yet now it's 1 year past your commercialization date, so you can't file an entirely new patent application. Ouch.
I know I don't do patent law, but I have to say patents.com is the website of a very reputable patent lawyer named Carl Alpedel. So
excuse me.
The point Ted is making is that there are a lot of services out there where they'll do it with trademarks too, that will tell you that you can get, they will search and file your patent or your trademark application for a very small fee, and they don't, I just happen to know.
No, I appreciate it.
Okay, and so these companies, I mean, I don't want to name any of them, but trust me, you'll know them if you see them. And people like us make a good deal of money and spend a good deal of time cleaning up the messes by these companies. If they tell you they're going to do the whole thing and search it and do it for $100, $200, trust me, they're not doing the entire thing, and they're totally misleading you. And I personally, this is just my soapbox, I find that absolutely disgusting, because people invest a little bit of money and then they find, like you're saying, you don't have the rights you thought you had. In the case of patents, it can be hugely expensive. In the case of trademarks, which we'll talk about later, it can also be hugely expensive. So just be careful. This particular one, that's okay. He's a good guy. Patents.com.
I apologize. I didn't realize, Jessica, thank you. I was banging the slides out, And I just made that up as a joke. I assumed that this was going to be, but anyway. But thank you. We will change that URL, and I'll put in a generic website, $150. So a question, real quick? Yeah.
Yeah, it has to be like new code, not something that you can find on like GitHub or whatever and be like.
I'm sorry?
It has to be like new code, like not like something like I pieced together like these 5 different GitHub projects.
Oh, no. Actually, that's a very good question. Let's say I have my novel speech-to-text algorithm that we're talking about, right? So I need something that will open an MP3 file and, let's say, and extract, decompress the MP3 file to PCM, you know, floating bit 16-point audio, 44.1 kilohertz sampling rate, right? So, how many attorneys know what that is? So you go to GitHub and you find an MP3 to PCM converter. Okay, that's fine. And then you go over here and you find something that takes, I don't know, whatever data structure you have. Well, you're probably going to end up writing it yourself, and then it spits out ASCII, or it takes ASCII and somehow generates the appropriate word thing, so now it's a .doc file, let's just say, right? I forget what you have to put in the file to make it .doc, but you know, the usual, whatever goes into that. So that is fine, because in there somewhere is, even if the elements, the pieces, the Tinker Toy sticks, may be prior art, the particular assembly of the Tinker Toy sticks may not be, right? I can take the little sticks and little wheels and plug the sticks in and make a new Tinker Toy pattern using the little Tinker Toy pieces, and it might be pattern no one's made before. That would be that would be novel. You see what I'm saying? So that should not deter you, the fact that you're using components, although if you're using GitHub components, let's go back to the copyright slide, you have the right license, okay, so you have LS Interacts. Another pitfall, you co-invented the innovation with your trusty coding contractor. Remember the coding contractor from the copyright slide? But you don't have an executed assignment of the patent rights, and they may be a co-inventor, in which case they have a joint ownership interest in the patent that you obtain. So then what happens is, you know what happens in those cases, and this I've seen, you have the patent issues, you think you own it, you don't really own the whole thing, you just own a joint interest in it. Your trusty coding partner has a drug problem. This is a real story. Has a drug problem and figures out you're really doing well with it, and he knows who your competitor is, and he figures out the fact that he owns half the patent, right? So he goes to your competitor and he sells his joint interest to your competitor for a big chunk of money. Okay? Seen it. Okay? Not that big a chunk of money. Enough chunk of money to be happy for a couple of weeks. I'm dead serious. This happens, all right? You've only figured out this prior situation when the patent application is under examination. Now, this is the case of the guy or gal is not so nefarious, but you find out they're the co-inventor of the claims because you're getting into some narrow claims of something they came up with, and it's under examination. You have deadlines to respond to the patent office, and the contractors run off with his supermodel girlfriend to Southeast Asia. We actually had this one. That was years ago, before you were. So that was interesting. So these are the kinds of pitfalls that are out there. This will change, and I apologize to the proprietor of this website because I meant that purely in the generic. There's so many of these websites now that do this. I mean, LegalZoom.
Well, I like it. Trademark is the way I.
Yeah, I know. We're going to have to mention that.
Not for patents.
Let's talk about design patents for 30 seconds. There is such a thing called design patents. It doesn't cover processes. You go, wait, why is it called a patent? Well, it really covers things like the appearance of a teapot. Okay, it applies only to the ornamental features of the invention or product. It can apply to a user interface, and we've actually gotten design patents on user interfaces. It can also apply to copyrighted design features. The two don't preclude each other. Different infringement tests from copyright infringement. But the difference between copyright infringement and design patent, although it sounds similar, is independent creation is not a defense to a design patent infringement. So you don't have to prove access to show infringement of a design patent. You just have to show that in the eye of the consumer, they look sufficiently similar. The pitfall here is, and we've seen this, I'm on the other side of the case of this, having to do with a robot toy. The plaintiff, as it were, owner of this robot toy hired a big law firm where one hand doesn't know what the other is doing. So one attorney extolled utilitarian features of the robot to get a utility patent or attempt to get a utility patent over the robot toy, okay? But then the other attorney on another part of the country who's getting a design patent argued that the invention was purely ornamental in order to get the design patent, right? But you can't have both. So design patent can only cover ornamental features. So one attorney is saying, well, there's nothing utilitarian here. This thing's purely ornamental. And then meanwhile, for the utility patent, the patent attorney is going, there's nothing here ornamental. This is purely utilitarian the way the robot toy works. No. So both are at risk, basically. If they ever sue my client, their whole thing blows up. So also design patents, that 1 year period is now 6 months for design patents. Any other questions about design patents real quick? Yes?
In deciding between getting a design patent or getting copyright protection, and let's say, for example, you're advising the client on one or the other, what would be those factors you would look at to say, do the design patent versus the copyright, or copyright versus design patent?
That's a good question. Well, in the copyright case, it's cheaper and easier to get, thinner protection. The design patent is more robust. So if it's going to be a ornamental feature that's going to be used a lot or over a long period of time, you're going to make an investment in that ornamental feature, I would definitely be adding design patents to the list. So in the case of the computer, we've gotten design patent. We got a design patent over spatula, right? So I got a design patent over the Star-Spangled Spatula. When you go to the store and you see a spatula, a metal spatula that looks like stripes and stars, I got 5 design patents over that. Okay, why? Because they were investing in selling that product. And that was the best way to protect it. Copyright's a little shaky.
But what were the non-utilitarian parts of a spatula?
Because it was the look of the spatula. It wasn't, we weren't saying a device made of thin metal that can be slid between a hamburger and a grill, right? Or a method of flipping a hamburger comprising sliding a thin device between a hamburger and a grill. We weren't doing that. We were saying a spatula that looks like this and it had pictures. And we filed it on with circles as the stars, stars as the stars, and squares as the stars. So we have 3 or 4 design patents over that whole idea. Yes?
Yeah, I mean, if you were trying to do something like that with copyright, you would end up having to prove to the Copyright Office that the features you're trying to register are not functional. It's a different way of saying the same thing. You talk patent is utilitarian. In copyright, there's the functionality doctrine, so you can't register anything that's functional. So if you have like a shoe design, you have to, or a spatula design, you would have to prove that the aspects of it that you are trying to get copyright registration over are not functional, and that can be a real pain in the neck. I don't know what it's like.
Well, there's recent case law on that actually.
There's a lot, actually.
It gets very, very. There are ways of filing copyrights on things that are in fact functional if you can separate the expressive aspect from the functional.
They have to be separable.
We could spend
yes,
an entire 2 hours on that topic alone. It's fascinating. That's why we do this work. So now we move to trade secrets really quickly. I'll breeze through that. Any information you derive, any kind of independent economic value, and protect with reasonable efforts from public disclosure, which goes to your issue regarding software itself, source code, of course, being an example of a trade secret. Customer list, vendor list, financial data, business plans, computer code, data files, that all can be a trade secret. Registration is not a requirement, but the pitfall is not treating your trade secret like a trade secret. So you have no systematic use of consistent confidentiality provisions in licenses, contracts, and NDAs. You'll let some people see the data because you trust them. You don't have them sign. Other people sign. Now you have inconsistencies there in a litigation over a trade secret. That will come out and blow up the status of the thing being a trade secret. Simple one, not locking down your compute infrastructure. And the first way to maintain your trade secret is not make it physically impossible to get the data in the first place. Hello? Now, filing a patent application on it can destroy its trade secret status. And that's why when we talk to clients about their overall business strategy and IP strategy, we start balancing some of this stuff out. And that's something important conversation to have is to when you're going to, why one would file a patent application versus not filing. Question?
Yes. What do you mean by locking down computer infrastructure? I'm not familiar.
Oh, make sure you have firewalls up that are maintained. Make sure that they have the proper protocols in place. Make sure, most importantly, this goes to how you handle HR, human resources. You have a very active and careful process for vetting people, giving them the password, and deactivating the password when they cease to be affiliated with your company. Also, what some companies do is they compartmentalize data very well. So they know that there are inner sanctums of technical development that other people can't physically get access to. Yes?
So like if you work for another company and they gave you a laptop, you're saying you shouldn't use that laptop to like develop your software because they could...
Oh yeah, that's a whole, that gets into a whole employment law issue, which I wanted to touch on, and I think I have one of the slides that kind of get into that. There's a whole thing about that. If you're working on your idea, you think it's your intellectual property, the first thing you need, and you're doing that at home because you have a day job, right? You work over here at Google, and you want to, how many people here work for Google? Okay, how many of you work for Facebook? Okay, how many of you work for Amazon? All right, good. So you work for Facebook or Amazon, right? And you are now developing a new thing you're going to launch your company with because your cousin is a big venture capitalist or wherever. Okay, so the first thing you need to do is you have to get advice on your employment agreement because it's going to have clauses in there that talk about whether the work you do at home is considered the intellectual property of your employer. It has to do with the relevance of what you're doing to what your employer is doing. Now, we just did a project where we're working on that, negotiating with a, shall we say, a large medical organization with extensive research in areas of cancer involving computer stuff, where they have come up with something that was not relevant to their employment, was relevant to the company, but not relevant to what they were doing at the company. Okay, and that was interesting. So that was why they were not subject to their particular employment agreement. But so that has to be looked at carefully. But also, when these things get litigated, those signposts are very dangerous. You develop the code on your company laptop. Use your company's cell phone to call the venture capitalist to set up a meeting, right? You're talking to your customers, they call you up at 3 in the afternoon, and you're picking up, you're calling your customer from your phone at your desk at Google saying, yeah, no, we can get that fixed, don't worry, I'll get back to you by tonight, right? Get your own phone, get your own laptop, get your own email address, okay? That's my advice on that. So, okay, let's move on from here. Trademarks is trade secret pitfalls. You sign NDA, it only keeps verbal disclosures confidential or follow up with a document, but you forget about the follow-up. I'm sorry, I'm going to give you 20 seconds on this because this is a real pitfall here. There are many NDAs from big companies that talk to you. So you're the startup, you talk to the big company, they go, anything verbal is kept confidential so long as we get, I don't know, some kind of a document within 20 days, I don't know, saying what it is you disclose. Routinely, this document never comes back. And now they don't have an obligation to keep that verbal disclosure confidential. You sign an NDA that has a sunset on the duty of confidentiality, yet the trade secret you disclose has a longer longevity. You with me on that? So it's a trade secret that is going to last longer than 2 years. You sign a 2-year sunset. This is another one that I've seen people that negotiate NDAs. It measures the sunset from the date that the agreement was signed, not the date of disclosure. So it says 2 years from the date of signature. So a year and a half out, you tell your counterpart, oh, this is the magic sauce. Well, they don't have to keep it confidential. They don't even refrain from using it for 6 months. You disclose your source code in an escrow arrangement without a duty of confidentiality. I saw one of these, a source code escrow that had no duty of confidentiality in it.
Was that malpractice, whoever?
I don't know. Well, this is where this came up was the escrow agent didn't steal the code. This came up in, was it a trade secret? Somebody else stole the code in violation of their NDA. But the NDA said confidential information doesn't include information disclosed without a restriction. Okay? There was no restriction on the escrow arrangement. And it disqualified the code as being confidential information. When this came out in discovery, that case settled really quick. And this gets back to you disclose product plan that are under NDA with party A to potential customer B, not under an NDA. So again, now A can say it wasn't really a trade secret. You consider your software a trade secret, but you widely disclose it without a well-drafted license form. We've seen that many times. You store customer data on a server that's not properly secured and it's hacked. Well, in that case, go to our prior panel on data protection. Do we have that on the web, the video? Yes, question. Real quick.
How enforceable are NDAs?
Well, it depends on the NDA. I can draft you an NDA that's 14 pages long, right? So generally what we do when we're brought into it, I don't know, corporate lawyers may have a different philosophy. When we're involved with a deep negotiation, it's sort of like dating, there's first base, second base, third base, home. So first base has a sunset, it's 2 pages long, and I tell the client, don't tell them anything, but very generally. Then what they do is, if they're interested, they're going to go, well, can you tell us how it really works? They go, no, under this NDA. Now all of a sudden the NDA they didn't want to talk about, they'll talk about that NDA. That's second base, has a little bit more to it. Then they finally go, well, can we get a copy of the source code or a copy of the code to test it? You're getting a third base. It has an 8-page, 10-page NDA, may even have non-compete components and things like that in it. So we generally find, we have like 5 or 6 versions of NDA. When you call someone and say, hi, I need an NDA, we have to have a conversation to decide which NDA is it in that spectrum of NDAs that you need. Okay? So,
We drafted 14-page NDA?
I
That's
have,
impressive.
and with 2 very sophisticated technologies.
What size was the font?
What?
What size was the
That
font?
was 12. We got into a lot of stuff about, we got to see your patent applications that you file within a year of the,
Wow.
Trademarks, so trademarks, Jessica, correct me if I'm wrong, I'm going to breeze through this, protects any insignia, word, graphic, or sound that conveys to the consumer the identity of the source of goods or services against someone's unauthorized use of a confusingly similar.
Okay,
You probably have a better formulation, so you can riff on that.
Here, the thing is, all that stuff about the word and insignia and graphic, yes, that conveys source, yes, that's right. I mean, the keystone of trademark infringement is likelihood of confusion. Is it likely that someone, if you start using this trademark, that someone's going to think that your products really come from him? Or your products somehow are endorsed by this other company, or that there's some connection. So likelihood of confusion is determined with a bunch of factors, one of which is whether the marks are confusingly similar to each other. So yeah, the marks have to be close, the goods have to be related, the goods don't have to be identical. So when you're looking to see if you're doing a search in advance and you're looking to see whether there's other marks out there that your mark might infringe, you really should have a trademark lawyer do it, because if you just look for the exact product that you're making, that's a mistake, especially because...
Well, not just the same product. If you have a similar mark out there, so you're going to come out with McDonald's spelled McDonalds, right? I mean, that's going to be trademark. You do string search on that, it's not, you're going to say, "Gee, that's clear."
It could be the non-identical spelling, it could be non-identical but related goods. And now, in today's world where one company, I mean, we can look at Amazon, I guess, but where companies sell, one company will sell such a wide range of goods, almost anything, I mean, can be related to anything else. I mean, I wouldn't say that jewelry was related to automobile tires. That's kind of extreme. But a lot of products that you might not, that in the past might not have been considered related, were considered related. Yeah.
You know where we run into that in fashion.
Well, there's fashion,
right?
yeah.
You file on clothing, whatever your thing is on clothing, and the patent office rejects it because there's eyeglasses.
It's the trademark office, but it's the same, it's the USPTO is both, but yeah, so for example, clothing, although I wasn't going to say that because it's technology panel, is related to skincare, is related to jewelry, is related to accessories like belts. I mean, you really have to have someone who knows what they're doing do this search.
Well, in technology then, you have software, you're going to sell software service, so you're going to be in what they call class 41 or 44, and then somebody has a similar mark in class 9 already registered. Patent office will pick that up and say, well, it's too close, class 9 is downloadable software or software on a disk. Class 44 is operating a website that provides software services. Different classes of use, it's how they organize the trademark system, but the trademark office will say those are similar. But what the trademark office does, examining your trademark application, which you have to file and get through the trademark office, is different than if you're infringing somebody's trademark. And that goes to Jessica's mention of search. Big pitfall. You come out with your trademark, you spent a lot of money on it, and you didn't search first to see whether somebody else has a substantially or confusingly similar mark that you're stepping on their senior rights, because they'll come after you and make you stop using the mark immediately, and that can cost a lot of money. There was a question back here?
Yeah, so I noticed like about a year ago, there was a video that came out for Alexa that was this little kid said, Alexa, play this song that sounds like blah, 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 and Alexa tried to play this inappropriate thing. And now I'm walking through Times Square a few days ago, and I noticed that they have an advertisement that says, Alexa, play the song like dot, dot, dot. Could that family have trademarked that and been like, this is ours now?
Well, you can trademark slogans. I mean, it's, I don't know all the specifics exactly. You know what he's talking about exactly? I'm not.
I don't know the incident that you're talking about, no, but I mean, a word can be a trademark, a slogan, a logo, a scent, and a sound. I mean, it's very hard to get the sound and sense. I don't know, I can't respond to that.
Here's a sound here. I mean, here's a sound logo. Ba 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 ba. That is a registered trademark.
Could you trademark, like, let's say I said my trademark's gonna be, Alexa, this song sounds like.
Yes, you can trademark slogans. In fact, we've done that. We've actually
Even
trademarked
though
slogans.
that Google or Amazon has come out with Alexa.
Oh, well, that gets to the question of whether or not the use that you're using it for is bona fide use in commerce for your product. If they're not using it to sell a product, they may not have a claim against you for you using it actually on a product. In fact, we've even gotten into a snit where somebody claims that they were like a contractor, that they came up with the idea for a trademark that my client ultimately registered. Now, the person worked on the project, but the fact that they came up, even if they did come up with the quote-unquote idea for the trademark, they weren't the ones using it in commerce. My client was the first user in commerce. They said, great idea, slapped it on the product, filed a trademark registration. They don't have a claim. It doesn't matter that it was their idea first. There's no proprietary right in that. The proprietary right is in the use of the trademark.
Yeah.
Well, let's continue. Oh, go ahead.
One small thing, which is just people sometimes don't realize this. A trademark doesn't exist as a right all by itself out there. It has to go with the specific goods or services that it identifies. So, for example, somebody once asked me, could I get a trademark for the coffee business? Like, no, I can't. You know, it would have to be for the coffee, for the retail sale of coffee, for teaching people how to make coffee. So it has to go with the specific goods or services that you want to protect. And there was something else I was going to mention, but I forgot to go.
All right, so this is an example of a trademark registration that you get back. So this is, well, it turns out it's also Workshare. So that's their logo, interlocking logos in 9 and 12 for, how does that say? For something to do with downloadable software and operating a website, software on a website, I can't really. User manuals, edited documents, whatever. So on the principal register, first use date in commerce, December 1st, 2012. The mark is its description of the mark, its serial number was filed in 2013. Here's the examiner down at the patent office, and that's the logo. There's the registration number, registered in June 3rd, 2014. So let's talk about pitfalls. I'm sure Jessica has a lot to say here too. Domain registration is not a trademark registration. Don't say, oh, I own the trademark, I own trademark.com. No, you own a domain, trademark.com. Somebody else can go file now, trademark, whatever it is, at the trademark office, get federal registration, and force you to give them the domain name.
Also, a corporate name, if you register the name of your company in the New York State Department of Corporations or Delaware, that's also not a trademark registration.
Oh,
It
thank
doesn't
you for
give
that
you
one. I
that.
forgot to put that one. That's the other one. I own the trademark.
You
We're
need
called
some stuff
Trademark
for me.
Trademark Inc. Right? So, yeah, that's another pitfall. So, owning the URL, registering the corporation's name down in Delaware or New York does not constitute use in commerce of the trademark on the goods or services. That's the key thing. So, and we just talked about this. Here's another pitfall. Investing in a brand that hasn't been cleared for use and also filed with the USPTO. So when it hasn't been cleared for use, you may release your product and be infringing from day one. And if it hasn't been filed with the USPTO, you may own what they call common law use in your local use, but somebody else comes along and files for a registration in a federal registration ahead of you, and now all of a sudden you're dealing with the fact that you can't stop them because they can say, well, you're a business in New York and we're a business under the same name in South Dakota. Question?
So you should always file with the federal.
Generally speaking, you have a brand that's being consumer facing. That's my recommendation.
No, he's
Search
right,
and
but
file. But go ahead, what's your view of
Well,
that?
no, it's just simply that the federal government only has jurisdiction over interstate commerce and international commerce. I think this is probably not an issue for tech startups, but I'll say it anyway. If you're only using or selling your product within New York, or since we happen to be in New York, you won't be able to get a federal registration. You have to be able to show that you shipped it or sold it across state lines or between here and another country. That's probably not an issue for you guys, but it does come up every now and then.
Right. Well, my view is most of these companies, if they're operating stuff off the website, usually they're going in interstate
Yes, if they
commerce.
have that, sure.
But
if
the
you
issue I'm getting at, anytime you have a customer, a consumer-facing business, you're going to be investing and building out your brand. You think over time the value of your brand is where the investment is really going to end up having value. You have to do this work way ahead of time. You clear the mark. You know for sure you can get it registered. You know for sure it's not stepping on anybody else's rights. We've done that many times for websites, as I'm sure you have too. And sometimes we've gone through 2-3 iterations getting the right trademark, because we'll run the search and we'll find something and go, nope, great idea, but somebody got there first, move on to the next candidate trademark. So yeah, really what it boils down to is you put your business plan together, think about not just one trademark you would use, think about 3. That's about the right number.
And one other thing, 'cause you didn't quite finish your previous slide. It's okay. So there are 2 ways in which you can apply for a federal trademark. One is based on actual use. I'm already using my mark, I'm already selling my product, which is what we just told you not to do, but you can do it. It's legally possible to do it. The other way is to file what we call an intent to use application, which basically says to the trademark office, I have a bona fide, good faith intent, I'm really going to use this mark on these products or these services, and you file that application
before you actually use it.
Before you actually use it, right. In the first instance, with an actual use, you file the application with a specimen of use and you tell the trademark office when you first used it. In the intent to use scenario, you're saying, I plan to use this mark, I really, really do. Obviously, you don't have a specimen of use because you're not using it yet. So you file the application, the trademark office runs through its examination process. If the trademark office doesn't have a problem with it, then the trademark office will, it gets published for opposition so that anybody out there who's monitoring other people's applications can see it. If everything comes up clear, they issue you something called a notice of allowance. At that point, for an additional fee, I might add, you submit your statement of use. See, here's my mark, okay? The problem sometimes with intent to use applications is, and you can get extensions of that, so you might be able to file your statement of use like 3 years after you filed your application. The problem we sometimes have with that is the mark that you thought you were going to use when you filed the intent to use, especially if it's a logo, has now changed slightly or actually a lot, so that the mark you're actually using isn't the one you filed for. It's hard to say, you know, that just happens. It's hard to tell you not to do that or how to avoid that, but just keep in mind as you go that if you have filed one of these intent to use applications, you should stick with the mark you filed for, or it's not, the application will have to be
Or call your
amended.
IP lawyer and saying, don't worry about the application, here's the new mark we're going to be using.
Yeah, there's that too.
All right, so where this comes up is, you're going to, and this comes to this, you're going to purchase $50,000 of ad buys in print, or $100,000 in packaging inventory. You don't want to make that investment at first and then file the application as in use. What you will do is you'll do a clearance and your attorney will say, yeah, I can't find anything. You'll file the intent to use, right? So you have a filing date, so you know you have a senior right to the trademark based on your filing date. And then you might feel more comfortable investing $100,000 in packaging inventory. Then when you get the packaging in, and you put the widget in the package and sell it, now you can say it's in use and you can get a registration. But you avoid the problem that you didn't file at all. You waited until you sold your first packaged inventory, and by that time somebody else filed in front of you. So you avoid that by filing the intent to use. That's why most of the time we're filing intent to use applications. Usually the in-use application is sort of, oops, nobody filed on this kind of thing.
And this one, that hypothetical or that pitfall thing also mentioned the trademark service we were talking about for $100.
Right.
I can't tell you how important it is not to use services like that. You will have a problem.
Now let me tell you, this is
Most of the
also,
time.
this is interesting. This is interesting because in the case of filing your patent application for you on a $150 service, theoretically there's supposed to be a registered patent agent. The trademark office doesn't have that. If you read the terms of service on these websites that will file your trademark for $100, you'll notice that they make very clear in the terms of use that you have to click through for them to do the service for you, that you acknowledge and agree that they aren't providing legal services, and that they're a company or a corporation. What they're trying to do is set it up that they're immune from being sued for malpractice, because you agreed in the agreement, you understood they were not an attorney, that they're purely a contracting service to do this for. Okay? And that's why they do that, because they know what they're doing is high risk. They're running string matches on the trademark you're submitting, and they all say, oh no, we have an AI program that checks for similarities, but a lot of stuff slips because it has to do with what do people think. And now I know that maybe eventually the IBM may end up in a business where they have to do this. I mean, their business is shrinking with the more sophisticated stuff out there, so maybe they'll end up running trademark searches on that computer, but anyway, go ahead.
Well, one more point.
Sorry, people
which
for
is that
IBM should have said that.
there's two, sorry, I don't know anything about patents, this I do. There's two different kinds of searches, generally speaking. There's a search in the USPTO, the Trademark Office database. That search will cover what's in the US Trademark Office database. It doesn't cover what's out there in the country, in the rest of the country, trademarks that are being used by people who never registered them. Now, why is that important? Because in the United States and Canada only, even if you get your trademark, your federal trademark registration, somebody who used, let's make it simple. You get your trademark registration for ABC for pens, okay? You have your registration. But guess what? It turns out, and you said that you first used this mark on pens January 1st, 2015. That's your first use date that's in the registration. But guess what? Now somebody comes out of, I don't know, Idaho and says that, wait a minute, I was using ABC on pens in 2014. Not only am I suing you for infringement, I'm petitioning to cancel your registration. That's because prior use in this country trumps a registration. There are still really good reasons to get a registration, but it's important if you can afford it, not just to have a USPTO search done, but to have what we call a full search done. A full search is something we order, at least I do, from a third-party search company that covers the USPTO in all kinds of permutations, so different non-identicals that most humans couldn't possibly come up with. State registrations, websites, domain names, company databases, all kinds of databases. It's pretty much the best assurance you can get that it's not foolproof, that your mark's not being used by anybody out there. And that means if you do that kind of search, you're in the best situation. Not perfect, but the best, so you won't be blindsided by somebody out of left field.
So yeah, that's really important. That's why we point this out, that this becomes, people get burned very badly by being too cheap on this upfront question of getting the trademark registration. But I want to turn now to another thing that I've seen where you've already got your trademark, you haven't registered, God bless, and you spent millions of dollars promoting the brand, and then somebody comes along and says, hi, you want to do this fancy deal because you're in the software business, and they're in the, I don't know, they're in, I don't know, they sell perfumes. So you go, gee, well, that sounds synergistic. We could get some money off the perfume business by calling our, we're going to sell Microsoft cologne. And so you grant them a license where it says, I hereby grant you the right to call your cologne Microsoft. And Microsoft will never do this because they have $1 billion lawyers working for them. But so now you're going to, the license just says, I'm allowed to sell Microsoft cologne as long as I pay you 20% of the net revenue. Sounds good, right? Well, there's all this magic language having to do with goodwill and whether or not the cologne and the quality of the product measures up to Microsoft standards, that is technicality that renders this kind of a license what we call a naked trademark license, which can be grounds for cancellation, because now the trademark isn't protecting the consumer. Remember I said that? What's the purpose of the trademark? Its purpose is to protect the consumer, not the trademark owner. So now if you're treating your trademark like, I don't give a damn what the product is, you pay me money, you can stick it on whatever you want, you treat it like that, the contract doesn't say there are quality assurance standards, we have a right to inspect the quality of your product, blah, 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 all that kind of stuff in it, is what we call a naked trademark, and now that trademark can be canceled. So if somebody else is infringing that mark, coming out with their own Microsoft cologne, can say, you know, the first Microsoft cologne, then the entire trademark can go up in smoke. Not just in perfume, but I think also potentially in software. So that's why, yes?
Question. So what if you have a registered trademark, let's say my brand is registered, And then domain names. So there are like so many domain names. Mybrand.com,
Oh, you mean the
mybrand.biz,
GTLD, sure.
not mybrand. So how? And
Well,
you possibly-
that is a problem, I mean, because some of those cost a ton of money, but really, the only answer is to have a completely unlimited budget and buy up every single, your name, every single domain name with every GTLD you can find, if that's what you're asking. That's the only answer, there's no.
I know that's really practical. What I do
No, it's
really
not. That's why I
if you
said it
have
like
a
that.
federal registration over your trademark, and you own, I don't know, whatever it is, brandx.com, and you're selling whatever it is, your competitor comes out and says, I know, we're going to call our website brandx.net. That's a trademark infringement. So you don't come to them saying, oh, you own the domain name, they're insulated. They're not insulated from trademark infringement because they own a domain name. If McDonald's owns McDonald's.com and I start selling hamburgers off of McDonald's.net, that's trademark infringement, I'm going to get crushed. So that's one of the purposes of the federal trademark registration, because that trumps domain names. You don't need to register 50 different domain names if you can sue for trademark infringement.
No, but I don't know if that's what you were asking. I mean, if you're asking to keep, it's always, that's why I was kind of joking, if you only have an unlimited budget and you can get every one, then you can sort of preempt that stuff before it starts. But most people don't have that money at all. And I just wanted to say one other thing, which is what Ted was saying about what happens if you have a naked license. Why is that important? Because what does a trademark stand for when you say they protect the consumer? A trademark is a sign of quality. I mean, you may not quite think of it like that way, but to speak as a woman here, if I buy a Coach bag, I may not know where exactly which factory that bag was made in, but I know it's going to be a good bag, top leather, top stitching, top whatever. So a trademark is a symbol of quality, and if you let someone else use it, so that's why it's an indicator of source. We said that up front, but we didn't really explain it. It doesn't mean exactly, again, the factory where it was made, or it means the company and the goodwill behind it. This is a good service. If I stay at a Hilton, I don't know maybe what your experience is with a Hilton, but I stay at a Hilton hotel, I know it's going to be of a certain quality. So if you let somebody use the mark without assurances of that quality, you're undermining the whole trademark. And the other thing about a naked license is, it is possible, I mean, there's two extra points to that. If you have a license that spells out quality control and you don't exercise it, then the person who's challenging your trademark rights also may prevail over you, even though your license says it. And the flip side of that is, it's not a great position to be in, but if your license doesn't say it, but you're actually doing it, then again, you may be able to come out on top.
That may actually be better than having a license that's not a naked license and never exercising
No, it totally is better,
so.
because the actual quality control
Is
will
what
be
counts, it's a
better,
fact. But the point is don't just
Don't
go
do
off
that.
and sign some back of the envelope license for Microsoft Cologne and think I'm good to go, I'm gonna make 20% off this deal. You could blow your entire trademark portfolio.
You need
Yes,
to
question?
consult an IP lawyer.
Well, here we go, which brings us to the next slide. Conclusion, start an ongoing dialogue with the intellectual property lawyer that you can establish a rapport with. I find that our most successful clients with this stuff, it's not people we hear from every 2.5 years, hi, I want to file a patent. We have like these ongoing conversations, what's going on, what are they developing, what are they doing, and the ideas start coming out of what you could be doing here with this, you could be doing with that. Like for example, I have a client, I forget how he got the client, this guy's from Bordeaux, and I've never met him, he emails me, I'm coming to New York, can we meet on Friday? Sure. So we had obtained a patent for him over a new kind of corkscrew, oddly enough, he's from Bordeaux. And so sure, I'll meet Philippe. So I meet the guy, and while I'm talking to him, it turns out, he's got this other line of work, I won't get into, it's attorney-client privilege, but he's from Bordeaux. And I was like, well, wait a minute, do you have a trademark over that? And he goes, no. I said, wait a minute, you're doing that big a deal in these states? And then we got to talk. So we had gotten a whole, so these conversations, this stuff comes up where now all of a sudden he realizes there's things that should be happening. And so what I'm getting at is I really hope to be invited to Bordeaux on a business trip. Yes?
So to follow up on her question,
Yeah.
your URL is sabetsy.net, right?
Yes.
So clearly you probably would have preferred the .com version. Why are you
My sister got there first.
Okay. Is it your sister who owns it?
Damn it. And then she didn't use it for a while until she saw how successful I was getting to be. Then she started to use it.
So if someone else owns sabetsy.com, why are you not infringing their trademark?
Well, she sells herself now as sort of an angel investor. You know, she's my older sister. She gallivants around with high-tech people on the West Coast and East Coast in Europe and invests. She's not a lawyer, and I don't care, and she doesn't care. In fact, I have to talk to her.
I guess, but if you were not related, right? So if you were someone else who...
Well, no, the issue would be I'm an attorney and I sell legal services, right? She does some kind of consulting investment, you know.
No, but it's likely, like when I said with likelihood of confusion, it's how, among the criteria is how closely related are the goods and services. Is somebody likely to think that somebody who is an angel investor is also providing legal services? Not inherently, no, I would
No,
say not.
sophisticated consumers of both
Yes.
legal services and investment are enough to know the difference, that when you're talking to me about filing your trademark, I'm probably not the guy who's going to go, oh, by the way, I'm going to put $2 million in your company for 20%, right?
I mean, one of the other criteria is the sophistication of the consumers involved. So in this case, they would be reasonably, I mean, it's kind of funny, there would be sophisticated consumers, and yet there is an old trademark trial and appeal board case that says computer programmers are sophisticated, but they're not sophisticated at discerning trademarks. It's just,
Oh, really?
Yeah, very old
Find that
case.
sentiment,
I
I'd
mean,
love to see that.
really.
So do you understand what I'm saying? Well, in that specific case, there are differences in the services, and both services target a sophisticated consumer, which means they can discern the difference. Yes?
So like if I had like McDonald's here and I was selling hamburgers, but like in the UK they had McDonald's, but they were selling software. You couldn't include infringement rights because they were doing.
Well, that's
McDonald's
different. A trademark of extraordinary fame is viewed as having a real broad shadow. So if you try to sell McDonald's software, I don't know, I'd say that's maybe at the outer limits, but I know McDonald's stomps on anybody that calls anything McDonald's. I know for sure that if you tried to sell McDonald's beer, they'd stomp on it.
well,
even though
there's
they don't
also,
sell
I mean, there's something called trademark bullying, which is where there are companies like Monster that will go after anybody and everybody who tries to use the name Monster, whether it has any relation in the world to their product. So really, under a really legitimate, fair, reasonable test, a lot of their claims are absolutely ridiculous.
I mean, I can give one firsthand. A big trademark bully that we finished defending was Burberry. They are a trademark bully regarding their plaid. Anybody that has even a way different plaid, they'll go after. If they just feel it's got some beige in it and a little bit of red, they go after you because they own trademarks in the plaid. So that's the interesting thing. They have trademarks in the plaid. Now, why they did that, we'll jump, if you want to wait, we'll give you 20 seconds on that. Trademarks don't have a lifetime other than how long you use it. So Burberry's trademark over their plaid goes back decades. Patents only last 20 years from the date of filing. And copyrights, well, they last, well, they keep changing and it's very complicated. It's something like 99 years. The point being that for trademarks, just go on and on and on. So what I'm getting at is Burberry came after the client. They were using a plaid. I won't say here whether it was sufficiently similar or not, but most interesting was the plaid was in a lining with, it was clearly not a Burberry coat. It wasn't, it had other labels on it. It was in a stores that don't carry Burberry because of cheap, department stores. And it got to the point of the way they were claiming it that I thought that there was this thing they called, that there was a utilitarian function to it. We were getting ready to challenge them on that in the Southern District, and they caved in on their settlement demands and settled. So it's very interesting dealing with bullies. You have to really be prepared to go to war with them. But I think that our overall conclusion is that this kind of dialogue we're having now, you need to have that dialogue as you put your business plan together and think, how you're going to budget it, what priorities you're going to give to different regimes, and how they interlock. So, I mean, one of the things my practice prides itself on is really having an innate, a very, very deep understanding of the technology, because my background is a chip designer in the old days, but in software and hardware, but also that we try and put together an entire matrix of IP strategies that kind of interlock to establish a certain kind of almost like a crystal, these different ways that you're protecting the same kingdom in order to establish barriers to entry. And so on that, I guess I will turn this over to Paul. Thank you very much. All right.